students.
Morning, ma'am. Morning, ma'am.
Morning.
Morning, ma'am.
Thank you for joining today's revision session. And as always, please mute yourself unless if you have a question to ask or you have a comment to make. Before we start, does anybody have something to say? Does anybody have a question or a comment? Does anybody have anything to say? Okay. Today we are just gonna do a revision on distribution of assets. And you can just hold on, I just want to mute so that we don't hear background noises. So what I have done is I have done a 7-page summary of a distribution of assets, and I have already uploaded it on the My UNISA portal. So you will find it under additional resources. Yeah, I think it's additional resources. Just hold on. Yeah, you'll find it under additional resources. So what we'll do today is we'll just quickly go through it, and I will only focus on aspect which when we did this topic distribution that we did not talk about, and also I will talk about, we will discuss the criterion for establishing the extent of the distribution, because I received a query from a student who said he does not understand how the 3-quarter rules they actually work when the court determine how to redistribute the asset to the other spouse. Yeah. Just to briefly explain, distribution of assets occurs when parties or spouses are married out of community of property, but they have an antenuptial contract. And in terms of this principle, it states that the court is given the discretion to redistribute some asset from one spouse to the other spouse. And then secondly, there is a difference between black spouses and non-black spouses. So in the summary, I have divided here that for non-black spouses includes white spouses, it includes Asians, it includes colored, Chinese, any spouses who are not black people. And for non-black spouses to qualify for redistribution of the matrimonial assets, firstly, they must have been married in terms of civil law, and then secondly, they must have gotten married. They must have gotten married before 19. Just hold on. I just want to confirm the exact date. They must have been gotten married before the coming into operation of the Matrimonial Property Act, which came into operation on the 1st of November 1984, and they must have an antenuptial contract whereby they have excluded community of property, of profit and loss, and they have also excluded accrual sharing. This is for non-blacks. For blacks individuals, they had recently there was a constitutional court judgment which has changed the position regarding black people. But before the constitutional court case, in the case of Sithole versus Sithole, the law stated that black individuals who entered into a marriage which was out of community of property, and that marriage was entered into in terms of that marriage was entered into before coming into operation of the Marriage and Matrimonial Property Act, which came into operation on the 2nd of December 1988, and those black individuals should have gotten married in terms of Section 22, subsection 6 of the Black Administrative Act. Black individuals who fall or who firstly fell under this category were entitled to a redistribution order. Early this year, the Constitutional Court has declared the provision of Section 22, subsection 6 of the Black Administrative Act unconstitutional, and in terms of the judgment, all marriages that were entered into by black spouses, and those marriages were entered into before coming into the operation of the Marriage and Matrimonial Property Law Amendment Act, those marriages are now automatically in community of property. So this basically means that this provision that before the coming into operation of the Marriage and Matrimonial Property Law Amendment Act, in terms of Section 22, subsection 6 of the Black Administrative Act, it is no longer applicable. The spouses who can still make use of redistribution order are non-black spouses who entered into marriage before 1 November 1984, and black spouses who are only married in terms of customary marriages. Black spouses who are married in terms of the civil marriage no longer have the right to request the court to order redistribution of assets, because there is no provision which gives them the right to do that. Before I continue to talk about foreign marriages, is there anybody who has a question?
Good morning.
Morning, who's speaking?
It's Alexander.
Okay, Alex.
Is it Advocate Muladen?
Ntabisa Monageng is fine.
Okay, no, thanks very much. I just want a clarity, what you spoke about in relation to the non-black and the black spouses. You unfortunately is that I just happened to be the first time that I become part of this important session. So just if you can just in a nutshell just summarize again, because so that I can capture what you actually said when you were distinguishing the difference between the two orders. Okay, thanks.
If you are married out of, or if your marriage regime is out of community of property, and that marriage occurred before 1 November 1984, and you are a non-black, in other words, you are a white person, Indian, Colored, Asians, Chinese, you can, during the process of a divorce, you can ask the court that, for example, here's a housewife who throughout the marriage was a homemaker, and then her estate is sitting on zero, and the husband who was working, let's assume that his estate is sitting on $1 million. The wife can ask the court to redistribute assets from the husband's estate to the wife's estate, so that the wife does not leave the marriage empty-handed. So for white, I will use white people as an example, though it applies to anybody who is non-black. So for white spouses, if the wife was a housewife, as an example, and her estate is less or is sitting on zero, the wife can request the court to redistribute assets from the husband's estate into her estate, so that she does not leave the marriage empty-handed. This principle or this law only applies to spouses who were married from 1 November 1984. So if you got married, let's say in December 1984, and your marriage is out of community of property, and then you decide that, or in the marriage, it is agreed that you will be the housewife and the husband will continue working. Because the marriage would have occurred in December 1984, that spouse or that wife does not have the right to request the court to order redistribution of the matrimonial assets, because this privilege, I will call it privilege, this privilege is only given to spouses who were married from 1 November 1984. The aim is to make sure that the spouse whose estate is lower does not leave the marriage empty-handed, if I were to call it that way. This is with regard to white or non-black spouses. Now, when we talk about the black spouses, the same principle occurs, but with them, it was from 2 December 1988 going backward. So if you are a black individual or a black spouse and you entered into a marriage which is out of community of property, and for black people it was automatically out of community of property, there was no option to enter into an antinuptial contract. So if your marriage is out of community of property and then it was entered into on or before 2 December 1988 in terms of Section 22, subsection 6 of the Black Administrative Act, that spouse, whether wife or husband, had the right to request the court to redistribute assets, let's say from the husband into the wife's estate, so that the wife does not leave the marriage empty-handed. So this was, for black spouses, this was the position up until early this year, when the Constitutional Court, in the case of Sithole versus Sithole, declared the provision of Section 22, subsection 6 of the Black Administrative Act unconstitutional. And because they declared it unconstitutional, they ruled that all marriages, all civil marriages that are entered into by black spouses, irrespective of when they have been entered into, they are now automatically in community of property. So if you got married, let's say on the 1st of February 1988, your marriage is now automatically in community of property, because Section 22, subsection 6 of the Black Administrative Act has been declared unconstitutional. Now, when it comes to redistribution, the most important factor in redistribution is your marriage must be out of community of property. So if for black spouses, if all the civil marriages are now automatically in community of property, unless if the spouses enter into out of community of property, the redistribution asset is no longer applicable to black people. Let me just repeat this. Remember, for black people, before the Constitutional Court judgment, if your civil marriage was entered into before 2 December 1988, it was automatically out of community of property, and then you had the right to request the court for redistribution of assets. And the redistribution of assets, you requested it during the process of a divorce. Now the Constitutional Court have declared Section 22, subsection 6 unconstitutional, meaning that even if you got married before to December 1988, your marriage is now no longer out of community of property. It is now automatically in community of property, and redistribution of assets is no longer applicable to you. And then the other important factor is the date. Ne? For non-black spouses, if you entered into a marriage from 2 November 1984, even if your marriage is out of community of property, redistribution order, the court cannot consider it for you, because the time period was only for those who entered into a marriage before 1 November 1984. So for black spouses, because the time period because the time period was limited to those who entered into a marriage before 2 December 1988. So anybody who enters into a marriage, let's say from 3 December 1988, and their marriage is automatically out, not automatically out of community, their marriage is out of community of property because they signed an antenuptial contract and they agreed to get married out of community of property, they cannot request the court for redistribution of assets. Before I continue, Alex, do you understand now?
Yeah, no, I understand. So what I want to check very quickly, because I see that there's some hands. So
Okay.
when you request that the distribution order, what then are you going to, the court is going to determine the percentage which
Yes.
the wife is going to get from that this redistribution, or it's because between the spouses that must determine? Because as you have rightly indicated that for instance, the wife is not working, I'm working, there's a particular, obviously I've amassed a lot of assets and quite a number of things. So in terms of determining the percentage of redistribution, who has to determine that particular allocation?
Okay, that on the summary is on page 3.
Okay.
Ne?
All right.
Under the heading, the criterion for establishing the extent of the distribution.
Okay.
So when the distribution was introduced, some South African courts adopted the guideline that the spouse who requested distribution needed to get only 1/3 of the total value of the spouse's assets. So there have been conflicting judgment regarding whether a spouse must get 1/3 of the other spouse's assets. For example, in the Beaumont versus Beaumont case, the court rejected the 1/3 as the starting point. The court held that the most important feature of our legislation, which is the court must take into account when exercising its discretion. Here, distribution, it is at the discretion of the court. So the court can refuse to distribute assets. So in the Beaumont case, they held that the court must take into account when exercising its discretion is assessment of what is just, having regard to the factors specifically mentioned in the Divorce Act. So above there are factors that the court looked at. So they are also in this summary. And then in the Based on Haiti case, the Supreme Court of Appeal reiterated that the court must start on a clean slate and not use guidelines or starting points. But and then in the Based on Haiti case, the court rejected that equality should be the yardstick and that spouses' estate should be divided equally unless there is good reason for not doing so. And then in the child's case, they held that our courts are not entitled as a matter of course to divide their joint net assets equal, regardless of their respective non and equal distributions. And then I did a table of cases here where also there are other cases, like for example in the Joubert versus Joubert. Here they used the 1/3 division. So as things stand now, the general principle is, okay, the courts, you can use the 1/3 rule as a starting point, but the other cases, they said no, you need to do what is just and fair for the parties, and then in other cases they redistributed their assets equally, and in other cases they did not do that. So at the end of the day, the discretion is the court's, is at the court's one, and then each and every case is going to be based on its own merit. So there is no general principle as to how should the court redistribute the assets. Are you okay, Alex?
Yeah, no. I thank you very much, but I think I will just have to go through the prescribed book again on those cases that you spoke about. But for now, let me just pause there to allow other fellow learners to actually interrogate the discussion.
Okay.
Thank you very much. Thanks.
Okay, Mishak.
Good day, ma'am.
Good day, Mishak.
Yes, I just want to clarify. Civil marriage is automatically in community of property, isn't it?
Yes.
Okay, so if maybe there is a death, or maybe there is a divorce, the court, we must order the court redistribution.
Okay, no. Remember, the first and the most principle is only spouses for non-blacks who were married before 1 November 1984 and whose marriages are out of community of property because they had entered into an antenuptial contract where they excluded community of property and they had excluded accrual. The spouse whose estate is lower can request the court to redistribute assets. So if your marriage occurred after 1 November 1984, you cannot request redistribution of assets because this provision is not applicable to you. It's only applicable to those non-black spouses who got married from 1 November 1984. And for black spouses, those who got married before or on 2 December 1988, they could request a redistribution. But now, this provision is no longer applicable to them because the Constitutional Court has said that black spouses who are in civil marriages and those civil marriages were entered into before 2 December 1988, those marriages are now automatically in community of property. So redistribution no longer applies to them because you have to be married out of community of property for you to request the court to redistribute assets. Do you understand? Mishak? Mishak? Okay, Mishak is on mute. Daniel? Daniel?
Hi, ma'am. Thank you for taking this question. Ma'am, I still struggle with this 1/3, 2/3 division thing because I can't remember exactly where I read. They said that if the court sees that the one spouse will be prejudiced, then the court may make a division order of 40/60, which is 2/3.
Mm-hmm.
And in the Barnhorst vs. Barnhorst case, they came up to a percentage of 34.79, which is basically 1/3.
Mm-hmm.
I still just don't understand when they choose the 1/3 division and when they choose the 2/3 division.
Okay, the simple answer to this is the court that is hearing the matter at the time has the discretion. So they look at the facts of the case, they look at what is just and fair, and they will decide whether we're going to do 2/3, whether we're going to do a 1/3, or whether we are going to do equal division. So if you read the various judgment, there is no specific or a general rule that says the court must follow this division. So the starting point is, okay, the court must divide or must redistribution using the 1/3 policy, if I may call it that way, but then the other judgments are against that, are saying no, but no, you cannot follow that as a starting point. So to answer you, if there is a question like that where it says, okay, do our courts use the 1/3? Do they use 2/3? Or do they use equality in distribution? There is no general, and there is no general factors or requirements as to what percentage can the court redistribute. There is currently conflicting judgment as to how the court can distribute the other spouse's assets.
So in other words, they work it on a case-to-case basis,
Yes,
basically.
yes, on a case-by-case basis.
And I do not see any calculation example in our textbooks of how they calculate it. Do we have to know that? Or
No, you don't have to know that.
Okay,
No.
100%, then I'm fine. Thank you very much, ma'am.
Thank you. Pumlani, Mishaki, please remove your hand. Pumlani? Pumlani?
Yes, ma'am. I just wanted to check, ma'am, in terms of the distributions of assets, especially for the black, my understanding is that prior 1984, if I'm not mistaken, the case is
Okay, you are cutting. I cannot hear you from my side, Pumlani. Can you repeat again? Pumlani? Okay, I cannot
marriages
hear
were
you.
regarded as out of property. That's
Okay, Pumlani, I cannot hear you. You keep on cutting.
Yes, ma'am.
Okay, please, Pumlani, I did not hear your question at all. Please write it on the chat because there's background noise and you keep on cutting.
Okay.
Okay,
No
please write
problem.
it on the chat.
Thank you so much. Okay, thank you so much.
Nkosi Zungu. Nkosi Zungu. Zungu, please unmute yourself. Jerome Nkosi Zungu, please unmute yourself.
Yes, ma'am. Good morning, ma'am.
Mm-hmm.
Yes. I'm struggling with the calculations. Whenever there has to be a redistribution, I've mainly in the past exam question papers. I'm struggling with the calculations. You know, I don't know whether it was your plan to do calculations in this session, you know, because that's what generated my interest in this session today.
Okay, I don't understand you.
The theoretical part, theoretical part of your presentation, I'm clear with it because it's all contained in the study material and it's all in order. But the calculations, whenever we're asked to do calculations, I struggle. I've seen past questions and answers to those questions, and I've tried to follow the calculations. I thought that it was not always logical and consistent, you know.
Okay, I still don't understand it, but we can talk about it privately. What I need to remind you, students, is that your exam will still going to be MCQs, so you will not be required to do any calculations at all, whether calculations for the accrual or whether calculations here. And then when it comes to redistribution of assets, because of conflicting court judgment, you need to know, for example, if you get a question which states that, okay, in which case did they decide that we are going to follow the 2/3 or the 1/3 or what? Those are the things that you must mostly specifically concentrate on, because remember, it's also going to be an open book case. So if you're going to be asked a question, the answer will be in the textbook. We are not going to be asking a question which is complicated, which is going to need you to know how to calculate or how to do what, but everything that will be in the exam, it is in the textbook. So as we spoke, I think it was last week when we had our session, where I said to you, the best way of if you get an exam question and you see that, you know what, I'm not really sure what is this about, I don't know where this is in the textbook, just look for a keyword in the question, for example, the distribution, or if it's a case, and then go at the back of your textbook under index or under a table of cases, and then look specifically for the page numbers where the question that is being asked. Look for the page numbers and go to those exact page numbers and quickly try to peruse and see if you cannot find the answers for that specific question that is being asked. One thing I assure you is whatever is going to be in your question paper, everything, all the answers are in this textbook. Understand? So just know that you will not be requested to do any calculations, but if there's any question that involves calculation or anything, you would have been given, let's say, the calculation, even the answer and what, and then on your textbook you will find the answer to that question that they have asked.
Yes, ma'am. When can I schedule a private session with you?
You can send me an email. My email address is monarkn@unisa.ac.za.
Please type it in the chat box.
Yeah, and then I will type it just now, and then you can send me an email, and then we will look at when is the best time for the two of us to
Indeed.
have a private session.
Indeed, thank you.
Okay, I've just sent my email address on the chat. Okay, thank you for that. The next one is Karabo. Pumlani, please remove your hand. Karabo.
Good morning, ma'am.
Morning, Karabo.
I wanted to ask a question. I don't know if it's related, but it's all about the African. It's all about the African marriages and the civil marriages. So I wanted to know about the community of property. I, for one, I want to do a community of property. So I'm a black person. So is it applicable to do a community of property? For example, maybe if I could, maybe my assets given to my children, not my wife, can it be applicable?
All marriage regimes in South Africa are automatically in community of property. So it does not matter whether you enter into a civil marriage, a marriage in terms of the Civil Union Act, or you enter into a customary marriage. The default marriage regime in South Africa is in community of property. And then if you want to enter into an out of community of property marriage, you need to enter into an antenuptial contract. The antenuptial contract must be signed and registered at the deeds office before entering into the marriage. Please note that before your exam, you must know the different types of the marriage regime. So students, what you need to understand about marriage is that we have the marriage legal requirements and we have the marriage regime. So you enter into a marriage and you need to follow the specific legal requirements, whether the requirements in terms of the Marriage Act, whether in terms of the Civil Union Act, or in terms of the Recognitions of Customary Marriages Act. And then when it comes to the marriage regime that is in community, out of community of property, the law is the same, irregardless of which marriage act you entered into. You married in terms of.
Okay, no problem. Thank you for that.
Thank you. Millicent, please unmute yourself.
Yes, I just did that. Sorry about that. How are you, ma'am?
I'm okay, Millicent.
Good, thanks, man. I just have two questions, man. Firstly, it's when it comes to calculating the accrual, right? I don't know if I'm digressing from the actual topic.
Okay, yeah, you are, because the students, remember on the 24th of November, we are going to talk about the whole course.
Okay,
all the
okay, so then I
questions
should raise that
that you
question
have.
then.
Yeah, so but also you are free to send me
An email.
An email. Then
Okay.
I can answer you on email.
Okay, the other question, ma'am, I need to find out, right? If you pay lobola for somebody, right? Let's say if they say lobola it's 20,000, and then you pay 10,000, right? Like, I just need to know, like, is that like marriage sort of like recognized when it comes to customary marriages?
Okay, Millicent, next week we are doing customary marriages. Please join us next week.
So, okay, all of my questions are totally out.
For today, yes. Next week is
Okay, no, it's fine,
customary
man.
marriages, and then yeah.
I was taking chances. It's fine.
Okay, thank you.
Thank you so much, ma'am.
Famida?
Yes, good morning. Morning,
Hi.
sorry, I couldn't unmute there. How are you?
I'm okay, Famida.
Good, good. Just a quick question. So I know exactly what you're saying is, automatically all marriages are seen as being married in community of property. I'm also aware that if somebody wants to change that to a marriage out of community of property, there's a process to follow. I know they're going to apply to the High Court and all of that. My question, though, is there a prescribed period? So let's say somebody's married for 10 years and all of a sudden now they want to change to marriage out of community of property. Is there a prescribed period wherein one can apply to the High Court? And I know the ideal is you got to do it before marriage, but I think as people learn, they may realize after being married, now I actually want to be in, married in out of community of property. So the question is there a prescribed period after being married that one has that period to go to the High Court and apply for, to be married out of community of property?
Okay, there is no prescribed period, but there are legal requirements that you first must qualify for, or you must fulfill before you can actually, or if your court application is going to succeed. For example, it must be a joint application. So if your spouse says, I'm not getting involved, you can't even bring the court application because it has to be a joint application. Secondly, you must have good reasons why you want to change. So if you entered into a marriage and then 10 years later, you want to change from in-community to out of community of property, chances of that application to succeed is going to really be nil because changing it is regulated by section 21 subsection 1 of the Matrimonial Property Act, if I'm not mistaken. Yeah? And then in terms of this provision, changing from in-community of property to out of community of property, it is not a process that should be used to correct the mistakes that spouses have done. You need to convince the court firstly that before we even entered into an in-community of marriage, it was our intention to enter into an out of community of property marriage, but due to a certain fault which was done maybe not by us. For example, you entered into an antenuptial contract, but the notary did not send it to the deeds office to be registered. So if you cannot convince the court or give conclusive proof that it was really our intention to enter into an out of community of property, chances of success are going to be very low. And the other requirements, and the most important requirement, is all creditors who are owed 500 and above need to be made aware of this court application. Remember, when you are married in community of property, you have a joint estate. Your debts are mine, and then my debts are mine. So you need to prove to the court that no creditor is going to be prejudiced by your change. So being married for 10 years or even for 2 or 3 years, and then when you have debts and everything, chances of success again are also very neat, because the court needs to make sure that there is no third party whose rights are going to be prejudiced by your decision to change from in community of property to out of community of property. Understand?
Thank you, ma'am. Thanks for that. Appreciate it.
Okay. Alex, I see your hand, but I just wanted to go to the chat. Pumlani has written his question, and then the question is for black spouses, before the Sitole case, the constitutional court case, he's saying, I'm under the impression that the marriage prior were out of community property. Does that mean spouses had no share on other spouses' assets? Yes. When you are married out of community of property without the accrual system, but during those periods for black spouses who entered into a civil marriage, their marriages were out of community of property by default. So they each had separate estate. So upon divorce, the wife could not claim anything from their husband's estate. They were not entitled to 50%. Even for non-black spouses, those who entered into a marriage before 1 November 1984, and their marriage is out of community of property, where they excluded community of property and the accrual system, they do not have any claim over their spouse's estate. For non-blacks, the only way they can get something is if the court redistributes the matrimonial asset of their other spouse's estate. And the same principle occurred for black people. But as I have stated, for black spouses, the position has now changed. But for non-black spouses, the position remains the same. Okay, thank you, Mishak, for that. Okay, Alex, did you have a question? Okay, Alex, I see. We'll come back to you. Mishak, because I want to continue here. I saw that you sent, I look at your thing, or at your chat. Let's just give Mishak a chance.
All right, it's fine.
Hello, ma'am.
Hi, Mishak.
I'm already understand that civil marriage is in community of property. So I just want to check, in community of property, it does require parents to make a will for their children, or children are automatically excluded from the properties.
Okay, when you're married in community of property, you have 50% of your estate, your spouse has their own 50%. What you do with your 50% share is up to you. There is nobody in South Africa who has the right to inherit unless if a will was not left and you inherit in terms of the Interstate Succession Act. So children don't have the right to inherit their parents' estate unless if you leave them a beneficiary in the will, or they inherit interstate if the estate is big enough that it can accommodate the surviving spouse and the children. If two or more individuals in a polygamous marriage are married, each and every spouse remains an individual in their own sense, and they do not have a right to even leave inheritance for their spouses. So just know that you are free to leave your inheritance to whoever you want. You can even disinherit your spouse. Okay, I hope that helped. Okay, let's hear Sive. Sive? Sive?
Hello, ma'am.
Yes,
hello, ma'am.
Yes, Sive.
I wanted to ask, if I am married and then in community of property, and then me and my husband divorce, am I still liable for his debt? And is he still liable for my debt?
It's gonna depend on if you, the two of you entered into a settlement agreement and what are the terms of the settlement agreement. If there is no settlement agreement, it's going to depend on what the court order says. So if the divorce decree says division of the joint estate, you are liable for 50% of his debts up until divorce. So whatever debts that he makes after the divorce, you are not liable, but anything else that he had before the two of you got married or during the marriage, you'll be liable for 50%. Okay.
Students. Okay, thank you, ma'am.
Okay, students, okay, let's do this because today's topic is supposed to be about distribution of assets. Any questions that you have, can you please send them to me? Send them to me. I'm going to compile. I'm going to compile those questions. I'm going to compile the answers so that on the 24th, we are going to tackle these questions and in the manner that you guys, not you guys, sorry for using that, you students have actually asked them. So if you have any question in respect to anything in related to this model, please send me an email, ask that question, and I am going to compile them. I'll just do what we know as a question and answers. I'll do it in a document form, and then if I receive many questions, after answering them, I will upload them on the my UNISA portal under additional resources. So this will help so that somebody maybe would not have been aware that, you know what, there's this thing that, you know, it forms part of this model and I was also not aware of. So if you don't have any question which is related to distribution of assets, please send me an email and ask that question. Next week we are going to talk about customary marriages. So if you have a specific question that you want to know about customary marriages, please send it to me so that next week we don't just only talk about general, and we will also answer the specific questions that you have in relation to customary marriages. So today we are going to go back and talk about distribution of assets. For anything else, please start sending emails and I will compile a list of questions and answers for that. Yeah. Okay. For now, I'm only going to take Zanele and then we are going to go back to our document. Yeah. Zanele, for now, you are the last one. Zanele?
Are you not recognizing me?
Who's this now? Sorry.
Alex.
Alex, you've already spoken. I'm trying to give other people a chance. Like now, I'm looking at time and I also want to go back to the document. But remember, Alex, you are also allowed to send me an email because even the questions that I'm going to get today, I'm going to compile them in that document. Then I'm going to upload it. So it's going to make it easy for everybody to understand. So if you don't get a chance to ask a question today or I don't get a chance to answer you, please send me that question. I will compile it. I will include it in the list of questions so that everybody gets to benefit from your question and the answer. Yeah. Okay. Now I'm only gonna take Zanele and Palesa, and I'm going back to the document. Zanele.
Hello, ma'am.
Hello, Zanele.
I think there may be a problem with our classes on YouTube, ma'am, because some of the classes, when I went back to revisit them, our old classes, some of them aren't playing, and some of them they are playing. So, what could be the problem?
I'm sorry about that. I think it's technical issues because remember, when I begin the session, I just press record. So Microsoft Teams records itself. Then afterwards, it just sends me the recorded link. So I apologize if there are technical issues, but that is something that is also beyond my control. Sorry for that, Zanele. Palesa.
Hi, ma'am. How are you?
Hello, Palesa.
Hi, ma'am. I'm just thinking, if people got maybe they say the other spouse got the redistribution, was it also possible for them to apply for maintenance, or if you did the redistribution order, you don't do maintenance? Thank you.
Okay. In deciding whether to redistribute assets, maintenance is some of the factors that the court look at. I did a summary here where, okay, let me see. Here they say the nature of the discretion, because remember the court has the discretion. So There are conflicting views as to whether the court exercises a broad or a narrow discretion. For example, in the Brewment, it was held that the discretion is very wide and that the appeal court may interfere with the discretion of the trial court. Okay, let's go to this one. Present it was held that the discussion in the narrow set involves a choice between two or more different but equally permissible alternative, while discussion in the broad set. Okay, this talks about discretion of the court, and then this is the form of retribution. So there are factors that the court look at, and maintenance is one of them. And the other thing that the court look at is to make sure that by redistributing the assets, the other spouse is also not left impoverished. The court also looks at the conduct of the spouse who is requesting redistribution. For example, was there a misconduct in the marriage? For example, let's say, did they have an extramarital affair, and then by having an extramarital affair, this led to the breakdown of the marriage. So on page 2, here I have stated the requirements, and I said the following factors are also taken into account by the court: the existing means and obligations of the parties, misconduct, the clean break principle, the exchange rate, variations between the date of violation of the spouse's foreign properties and the date of the court's order, the need for finality of the litigation, the need not to jeopardize the financial survival of the business, which constitute a large part of the wealth of one of the spouses. So your question regarding maintenance, it will fall under the existing means and obligations of the parties. So if the spouse is also requesting, let's say, spousal maintenance, so in redistribution, the court will exercise its discretion whether to redistribute, and then if it has decided that yes, we are going to redistribute asset, it's going to come to the percentage, whether are we going to redistribute in terms of 1/3 or 2/3 or equally, but they have to look at the existing means. So if the spouse is going to be awarded spousal maintenance, let's say 50,000 of spousal maintenance, and then that spouse again wants a redistribution. So the court will have to take into account that, but with the spousal maintenance that that spouse is going to receive, it is a reasonably well lump sum. Will it really be fair and just that they also order redistribution? Understand? Again, this goes on a case-by-case basis. Yeah? Student, also what you need to bear in mind that if we are saying this applies to marriages which should have occurred before 1 November 1984, we are now talking about individuals who are now our grandparents. And then secondly, without sounding harsh also, a lot of spouses or individuals who got married before this period have already passed away. So there are those who are still alive, but the percentage is really not that high. So if the court is going to order redistribution, and then let's say the person who requests the redistribution is 90 years old, so the court needs to take that into account. But okay, with this estate, are we going to redistribute because we are now punishing this other spouse, or are we redistribution because this spouse needs this estate in order for them to move on with their life? So chances are that the more aged you are, the less likely that the court can order redistribution, but the court can order a reasonable spousal maintenance up until the death of the spouse who requires redistribution. And then as time goes, there's gonna come a time whereby redistribution will no longer be applicable because the individuals to whom this principle or to whom this provision applies to would all be dead. For all of us now who are alive, this provision of redistribution is not applicable to us, with the exception of black spouses who are married in terms of customary marriages. So one of the things that you need to know is the constitutionality of Section 7, subsection 3, which is redistribution. At the present moment, as I said, it applies to non-blacks who were married before 1 November 1984. So for those who were married afterwards, it's no longer applicable to them. For spouses who are in same-sex marriages, it's not applicable to them. For spouses who are subject to the lex loci domicile rule, that is, if you are married to a non-South African husband, or a husband whose domicile is not, or at the time of marriage was not, South Africa. This principle is not going to apply unless if the husband's domicile country also has the provision of redistribution in their own laws. And also, again, when it comes to black spouses who are married in terms of civil marriage, this provision is not applicable to them, but black spouses who are married in terms of the customary marriage, redistribution is applicable to them, and it is not only applicable to them because they are married in terms of customary marriages, it also does not matter when they entered into a marriage. So if there is a black spouse who, let's say, got married on the 2 of January 1972, redistribution, and then their marriage was or is in terms of customary marriage, redistribution is going to be applicable to them. So you need to know the constitutionality principle, but most importantly, if you are asking to whom does this principle does not apply to, you must know that same-sex marriages, it does not apply. If your husband's domicile is not South African, whether now or at the time of entering into a marriage, is not applicable to you. If you entered into a civil marriage, you are a black spouse, but your civil marriage entered into after 1988, it is not applicable to you. So on page 2, here under the constitutionality of the prerequisites in section 7, subsection 3, I have here listed the 2 constitutional court judgments which relate to redistribution of assets for black spouses, but one judgment, the Kumeta case, relates to those who enter into customary marriages, and the Sithole case relates to those who are married in terms of civil marriage. Okay, does anybody have a question? Let me go back here.
Just a follow-up.
Who's this, Mishak?
Yes.
Okay.
It's Mr. Zungu.
Oh, Mr. Zungu, okay.
Yes. Is it fair that in the upcoming examination, we are tested in a 2021 court judgment that is obviously not in the study material that would have been developed prior to 2021?
No, I don't think you're going to get a case regarding Sithole versus Sithole.
Yeah.
But
yes.
Yeah, but for the purpose of this session and for the purpose of knowing redistribution, remember, you are not only knowing this for the exam, you also need to know. So it was important for me to make you aware that although the textbook says this is no longer applicable. Unfortunately, the change happened after the course materials have already been developed, and it was already too late. So in your exam, let's say, okay, in your exam, I know you're not going to get about Sithole versus Sithole, but let's say you're having a discussion with somebody about the textbook, and then you are discussing this, and then you are saying, okay, for black people, for this period, this is the position. You can make them aware, but this is no longer the position. I mean, the textbook was written in 2015. You understand? And there has been a lot of development. But for your exam, please, I repeat again, whatever you need, whatever you will be examined on, the answers will be on the textbook. The answers will be on the textbook. It's going to be a 2-hour exam. I know 2-hour exam is really not that long, because you will need to be perusing into the pages to know, okay, this answer, this question, in which page must I go to try and find the answer. So that is why also I tried, not all the units that we spoke about, but I tried on the most important ones and the ones which are a bit longer to try and do the summary notes, to try and make it easy. But please, these are just the summary notes. You still need to go and read your textbook. But when you have a summary notes, at least it makes it much better. And then you read them, and then you also go to your textbook and also read that, what this is what the position is. On the summary notes, you will see here that I did a table of the cases, and then what I did, I drafted, or I typed what, in my opinion, what led to this court cases to be, the landmark judgment, or the most important principle that actually was said in the case. Because when you read cases, although everything is important, but there are some things that the court say that almost all the courts, or a high number of court cases, they actually follow that. So this is what I also try to do here. And also this helps, because you will know that when you receive a question and then it has something to do about the Matabate or Milbone, then you will know that, okay, oh, this is about the distribution, this is about what, because you can get a question which says in which court judgment was this stated, or in the Eastern Venhays or in the partner case, what is it that the court said, and then you're going to have different options which we need to choose from. You understand? So the purpose of today's session and also the purpose of the other session was just to try and make things a bit easy as you are navigating through this course, as you are studying on your own, because we know that UNISA is a long distance study, unlike the other universities. But we have now come to the conclusion of today's session. As I have stated, these summary notes have already been uploaded. And then secondly, as I stated again, please start sending me questions. Start sending me questions, because if you are going to discuss various questions or various queries on the prescribed textbook, and also on all the units that you need to know for the exam. If we have already a list of the questions that you want to know, it's going to make things extremely easy and better for all of us. Okay, now I'm going to take Mishak as the last one. Mishak?
Okay.
Mishak?
Yeah, okay, I have a small scenario here. Like me and my wife were in a civil marriage. So when we are in a civil marriage, I discovered that my wife, she already has a extramarital status with another man. So I decided to approach the court for a divorce. And on my side, I'm not working. She's the one who she's working. So who will be liable for divorce, for maintenance for our children?
Okay, maintenance for your children. Remember, you And parents have an equal responsibility to provide financial support for their children. But and the court will now look at what your earning capabilities are. So if you are saying you're unemployed and then she's employed, and let's say from this marriage you are not going to get much after the divorce, the court can order that she pays a high percentage of maintenance and you pay a smaller percentage. So it can vary from 60-40, 30-70, 80-20. But at the end of the day, it depends on the financial position of the parties.
Okay.
Okay, thank you. Alex, you are the last one. Alex?
Thanks very much. No, thanks very much. I just wanted to, but I think I got what I wanted. I wanted the confirmation of the email address where you said we should send questions, but I got hold of it. Thanks very much.
Okay, thank you. Students, I have sent my email address on the chat. So if you just look there, you will find it. Thank you for joining today's session. We shall meet next week, and next week we will be discussing customary marriages. Have a good day ahead, and all the best as you are preparing for your exam. All the best.
Thank you very much, ma'am. For you too.
Thank you. Okay, goodbye.
Thank you.
Thanks, bye.